This is going to be my Constitutional Rights and Protections by Logan Poole. Freedom of religion. I'm going to go ahead and give a little background on what freedom of religion is. The First Amendment guarantees two key protections: the Establishment Clause, which prevents the government from creating or endorsing a national religion, with the Free Exercise Clause, which protects individual rights to practice their faith freely. This means people are free to attend religious services, wear religious clothing, or even choose not to follow any religion at all. Over time, court cases have shaped how these protections apply in schools, public spaces, and government actions. I'm going to go ahead and share two key truths to freedom of religion. The first one is broad protection. The First Amendment protects all religions, including no religion at all. It applies to daily religious practices beyond just worship service. Second is the Establishment Clause. The Establishment Clause prevents the government from favoring one religion over another or even showing preferential treatment towards religions over non-religions. I'm going to go ahead and share a few common misconceptions as well. Christian nation fallacy. The misconception that America was founded on Christianity. In reality, the founders deliberately established a secular government to maintain separations between government and faith. Second, the limited scope misconception. This is the belief of freedom of religion only applies to attending worship service. Freedom of religion covers all daily religious practices. This can scope from dietary restrictions all the way to dress code and religious holidays. Second is freedom of speech. Also protected by the First Amendment, freedom of speech ensures individuals can express their thoughts, opinions, criticisms of the government without fear of punishment. However, this is not unlimited. However, this right is not completely unlimited. Speech that incites violence, makes true threats, or involves obscenities may be restricted. Importantly, the First Amendment protects against government censorship, not against consequences from private employers or organizations. This freedom is vital for democracy because it allows open debate, protests, and discussions of popular ideas. Here are a few of the key truths. The first one is government protection. The First Amendment primarily protects individuals from government censorship or punishment based on their speech. Second is offensive speech. Even speech that is offensive, hateful, or disagreeable is often legally protected unless it involves direct threat or incites violence. Thirdly, private versus public. Private employees are not bound by the First Amendment and can set their own rules regarding employees' conduct and speech. Here are a few of the common misconceptions that are framed around freedom of speech. The first one is workplace speech. The misconception that you can say anything at work without consequence. Private employers can discipline or terminate employees for offensive or inappropriate comments. Hateful speech fallacy. The belief that hate speech is automatically illegal in the US. While deeply offensive, it generally protected unless it crosses into direct threat, harassment, or incite violence. Thirdly, freedom of the press. This freedom allows the media to investigate public and criticize government action without censorship. It ensures the public has access to information and can hold leaders accountable. The press serves as a quote-unquote watchdog for democracy. The protection applies broadly beyond large news outlets to independent journalists, bloggers, or even ordinary citizens that just want to share their thoughts. While the government can't censor these or restrict publications, journalists must still follow general laws. These are connected to defamation. Here are a few of the key truths. The broad definition is the press includes not just professional journalists, but bloggers and citizens journalists as well. Second, the historical context. Journalists don't need government approval to publish a major difference from many other countries in history. Here are a few of the common misconceptions. Censorship fallacy. The misconception that the government can stop fake news by law. Any such attempt would be considered unconstitutional. Secondly, professional only misconception. The belief that only professional reporters have freedom of protection. In fact, anyone from bloggers to citizen journalists has these protections. Next, the search and seizure. Fourth Amendment protects from unreasonable search and seizure by the government. This means law enforcement generally need a warrant issued by a judge based on probable cause before searching someone's property or belongings. However, there are exceptions, such as evidence in plain view, consent by individuals, or even emergencies. Today, this protection extends to modern technology like cell phones, emails, which courts have recognized as a part of personal privacy. Here are a few of the key protections. Protects from physical property and digital data, guards phones, emails, cars, and location information. It establishes reasonable expectation of privacy. Here are the warrant requirements. Generally, law enforcement must obtain a warrant supported by probable cause conducting a search and seizure. Here are the warrant expectations. Plain view, evidence is visible without search. Secondly, the consent, when voluntarily given. Thirdly, is the exigent circumstances, emergencies, or threats. And last but not least, fourth is search incident to arrest, limited to ensuring officer safety. Here are a few of the common misconceptions. The first one is police can never search without a warrant. No, sorry, the misconception is that police can never search without a warrant. In reality, consent and urgent circumstances allow it. Misconception. Refusing a search makes you look guilty. In reality, it's a constitutional right to say no. Due process. The Fifth and 14th Amendment guarantee that no person shall be deprived of life, liberty, or property without due process or law. Procedural due process ensures fair procedures like notice hearings and trials, while substantive due process protects certain fundamental rights from government interference, such as privacy or family rights. Due process is a cornerstone of fairness in the justice system, ensuring individuals are treated equally under established legal rule. Here are a few of the key truths. Fair procedures. Due process mandates that the government must adhere to fair and established procedures before depriving an individual of life, liberty, or property. Next, the federal and state. 14th Amendment extends due process to both federal and state levels, ensuring consent protection across all branches of government. Third, beyond criminal trials. Due process applies to civil disputes, property matter, and civil rights cases, not just criminal trials. Here are a few of the common misconceptions. First one is criminal trial limitations. The misconception that due process only applies in criminal trials, it also applies to civil rights and property disputes at both federal and state levels. Next, guaranteeing outcomes. The belief that due process guarantees a good outcome is actually guarantees a fair process, not a specific result. A fair trial doesn't always lead to favorable verdicts. Next, the 19th Amendment. The 19th Amendment reminds us that, sorry, the Ninth Amendment. The Ninth Amendment reminds us that the rights listed in the Constitution are not the only rights people have. It prevents the government from claiming that unlisted rights don't exist. Courts have used the Ninth Amendment, along others, to recognize rights like privacy, personal autonomy. It serves as a safeguard against overly narrow interpretations of liberty. Here's what the Ninth Amendment says. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. The purpose and protection. Protects enumerated rights like privacy, guards against government overreach. Here are two of the common misconceptions. Thinking the Constitution lists all rights, believing the Ninth Amendment isn't important. The Tenth Amendment. The Tenth Amendment reinforces the principle of federalism. It states that powers not given to the federal government by the Constitution nor denied to the state are reserved for the states or the people. This division of power helps balance authorities between national government and state government. It is often cited in debates over states' rights for education policies to drug laws. Here are a few of the key points. The power distribution. The Tenth Amendment reserves powers not delegated to the federal government, to states, or the people, clarifying the boundaries of federal authority. Next, the states' right. Forms the foundation for states' rights, debating influencing areas from education policy to marijuana laws. The federal supremacy. Despite reserving powers to states, the Tenth Amendment doesn't grant states authority to override federal laws when conflicts arise. Here are three common misconceptions. Overriding federal law. The misconception that states can override federal law. In reality, federal law remains supreme when conflicts with state laws arise. Limiting federal power. The belief that the Tenth Amendment severely limits federal authority. The amendment actually complements the federal system by clarifying which power remains with states. Enumerated powers only. The misconception that the Constitution lists all three powers. In fact, the Tenth Amendment acknowledges implied powers not explicitly enumerated. Equal protection. The Equal Protection Clause of the 14th Amendment requires governments to apply laws fairly and equally to all people. Originally written after the Civil War to protect formerly enslaved people, it has since been the basis for landmark cases addressing segregation, gender discrimination, and same-sex marriage. Courts examine whether laws treat people differently and whether those distinctions serve a legitimate governmental purpose. Here's a few of the key principles. Equal treatment. The Equal the, the Equal Protection Clause requires the government to treat all individuals equally under the law without discrimination. Valid distinctions. The governments make distinctions if there is a legitimate, non-arbitrary reason, such as age requirements for driver's license. Beyond race. This clause applies to multiple categories, including gender, age, disability, religion, and more. Here's a few common misconceptions. Identical treatment fallacy. The misconception that equal protection means identical treatment in all circumstances. In reality, laws can distinguish if there's a legitimate reason. Limited application error. The belief that equal protection only applies to race. In fact, it extends to gender, age, disability, and other categories as recognized by courts. And last but not least, discrimination. Discrimination occurs when individuals are treated unfairly based on characteristics such as race, gender, religion, disability, or age. While not all discrimination is legal, civil rights laws prohibit unfair treatment in key areas like employment, housing, education, access to public accommodations. For an example, the Civil Rights Act of 1964 made a racial segregation in employment discrimination unlawful. Legal protection continues to evolve as society debates new categories of protection, such as sexual orientation, gender, and identity. Here's a few of the key truths. Limited illegal discrimination. Not all discrimination is illegal. Only specific types like race, gender, age, disability, religion, and national origin are prohibited in certain contexts. Civil rights coverage. Federal civil law covers workplace, housing, school, and public accommodations. Each category has its own specific protection and examination. Exemptions. Here are a few of the common misconceptions. Speech versus discrimination. The misconception that freedom of speech protects this discrimination behavior at work. Private employees can discipline or terminate employees for discriminatory speech or behavior. Exemptions, misconceptions. The belief that discrimination laws apply everywhere. In reality, private clubs and small businesses often have exceptions from certain anti-discrimination laws. In conclusion, understanding these nuances is crucial. While the Constitution and civil rights laws protect against certain forms of discrimination, they don't shield all behaviors. The line between protected speech and illegal discrimination can be complex, requiring careful consideration of context, jurisdiction, and specific circumstances. Thank you all for listening.